All right, we're going to go ahead and get started. Again, we might have a couple more stragglers. For those of you I haven't met, I'm Tim McColly, Education Director, and we're going to be going through some of the changes that are upcoming. First, we're going to be talking about the new marketing and sales agreement. And just for sake of time, if you would hold your questions till we get through the end of the marketing and sales agreement, and then we can deal with whatever questions people might have. Then we'll talk about the policy or practice changes that are coming about because of the NAR settlement regarding all of the lawsuits that have been going on. Then we'll talk about the buyer agency agreements that you use in Illinois. We'll talk about some reasons or how to present this to sellers and buyers. And I've got another form, which is the non-agency disclosure form that you use in Illinois as well. So let's go ahead and get started on the sales and marketing agreement. Hopefully you all have a copy of that. We should have went out. And just a couple side notes. We are in the process of finalizing the formatting. So there could be, again, some format changes before it actually comes out next week. And another change is they're going to be numbering all of the lines on the listing contract, so it'd be even easier to make reference to them. But at this point, we don't have that. So we're going to be starting with page 1. And really, there's no changes on page 1 other than, again, some formatting changes. You'll look at the top and see the exclusive marketing sales agreement, made it into and entered into as the inception date. And then you had other lines before that you identify parties. Well, again, that's been format changed, but all the information is still the same. So we can move on to page 2 then. And page 2, there's no changes until we get to the bottom of page 2, where it talks about the broker's commission. Tells you the broker's commission charged by the broker for services rendered with respect to any listing is solely a matter of negotiation between the broker and the seller. So this is our antitrust language that we are required to have pretty much in our listing agreements and buyer agency agreements. And it goes on to say that the seller further acknowledges and agrees that in a dispute between the parties over the commission, the prevailing party shall be entitled to reasonable attorney's fees and costs incurred in a dispute. And then at the top of page 3, it tells you the seller shall pay in cash to broker for services a total commission as follows. $395 plus 3% of the selling exchange conditional sale contract price. A minimum of $5,000 will apply to, plus $395 will apply on sales with a sales price of $80,000 or less. There are 2 versions of the sales and marketing agreement. The only difference is one of them says the commission will be 3%. The other one, the commission will be 3.6%. It will be up to you as to which one you want to use with your clients. We have some agents in the company that say they provide additional marketing materials when they are the listing agent and they do additional things, and they like to have an option for a higher compensation. But that's going to be up to you which one you use. And now it also tells you $5,000 on sales with a sale price of $80,000 or less. Well, if you take a percentage, what percentage $5,000 is of 80,000, well, that's going to be higher than normal. And there's kind of a reason for that. First of all, how many properties do you have under $80,000? Probably not very many. And if you have them, I can almost guarantee, from my experience anyway, there are problems. There are problems with the property. There are problems with the ownership. There might be title problems. And we have found that we spend a lot more time dealing with issues of very low priced properties than we do with a typical median priced home. So again, we're just recommending that because you probably will be doing more work. And where we reference the $395 being due to the broker if the agreement is withdrawn. Then we refer to the buy side commission, because there's been a lot of talk about buy side commissions going away. Are we having to provide our services for free? A lot of other things. And unfortunately, I think there's some misperception, especially amongst the quote experts out there that are saying things like, This is going to greatly reduce the transactional cost imposed by the parties. But the reality is we provide brokerage services to both buyer and seller, and we expect to be compensated for the brokerage services we provide to each. Now, in the past, and I won't get into the history of the mandatory offers of compensation unless we really would want to talk about that. But for decades, NAR has recommended two NAR-directed multiple listing services that, in order for a consumer, the seller, to participate in an MLS, they have to make an offer of compensation to cooperating brokers. And it's that mandate that others have said artificially inflate commissions because we pressure sellers into offering a competitive amount to a cooperating broker, and that's where it gets inflated. But nevertheless, there is a good likelihood that a buyer, in order to buy their house, might need some assistance. And therefore, concessions, not only potentially for financing, as closing costs and prepaids, but also maybe some assistance paying their buyer agency fee, because that allows them to keep more money in their pocket, which they can use as part of the down payment, which allows them to literally buy more house. And we'll talk about some of those things later in the program. So we should be having the discussion with the seller that we might want to still consider offering some buy-side consideration. So it says, all other participating brokers, compensation to others, state seller shall pay, and then we will fill in the blank as to what the seller says, sure, I will allow, and we put 3% if they don't fill in anything, but I'll allow 2.5%, 2% to the participating broker. We also want to encourage sellers to recognize that McColly also wants to bring buyers to their listing, and we're recommending that if it's a McColly agent, again, we're going to offer them 3% as a buy-side commission. Now, it's possible the seller says, oh no, I heard I don't have to pay those other agents. That's true. And it's up to you, Mr. or Mrs. Seller, that if we don't want to offer anything, we don't have to offer anything. Now, by law, we have to present any written offer that comes in on your property. And our experience shows us in talking with agents in other states that it is still common practice for a buyer to ask for some assistance in the payment of their buyer agency fee. So we can say 0, but I'm just opening you up the idea that it could happen. And when a purchase agreement comes in, just like any purchase agreement, we'll look at the pros, the cons, and make a determination as to what direction we want to go. Fair enough? So again, we're suggesting we position it with the seller that there still is a good likelihood that will happen. So when you get down to buy-side considerations, basically that's what we're doing. We're just explaining to the seller, again, all prices and commissions are negotiable. Here are the buyer agents. Seller understands buyer agents have a buyer agency contract, a client relationship, requiring payment to that participating broker. Buyers frequently negotiate to have their buyer agency fees paid by the seller as terms of an offer. And I won't repeat what we already talked about. So in the middle of the page then, it tells you the transaction shall not be closed, etc. But it tells you seller agrees and acknowledges that McColly Real Estate is not required, has no obligation to share or offer participating brokers any specific portion or percentage of the commission, that McColly Realtors has the authority to offer cooperating brokers. One of the edits that will come out will probably be replacing cooperating brokers, the new language, as part of the NAR settlement. We call them participating brokers. But again, that's just a semantics change. And we're just informing that we are not obligated to offer a certain amount of whatever buy-side is being offered. Drop down to paragraph C. Talks about leasing the property, and our typical leasing commission is going to be $1,000 or 1 month's rent, whichever would be higher. It goes on to talk about the protection clause. The protection clause, of course, is the clause in the agreement that says if the seller sells the property to a buyer that we cause to be interested during the term of our listing, and our listing has now expired, well, if that happens within 1 year, the seller is still obligated to pay the fee. Now, there's an exception if it is residential property. Residential property is property 1 to 4 unit residential properties. And after the expiration of our listing, it is listed with another licensed Illinois broker under an exclusive agreement. And that same buyer comes back and buys then. Nope, there's no obligation to compensate McColly Real Estate. However, if it's a commercial property, and again, anything other than 1 to 4 unit residential, then the protection clause stays in effect for 12 months, regardless of whether they have relisted that property with another licensed Illinois broker. If it is a conditional land sale contract, well, the fee would be $395 plus 3% of the total purchase price, which will be paid at the time they enter into the land contract agreement. All right, if we move on to the next page, which would be page 4 of 9, really no changes there. The actual physical change to the contract, we had the multiple listing service information there. That's been moved to later in the contract. So that's the only thing that changed there. If we go to page 5, no changes to any of the documentation. Under paragraph 17, referral relocation services, the auction option, which we used to have, which we don't anymore. So that's been removed. Again, the only change on page 5. If we get to page 6, we're looking at the first change being paragraph 26, which is the indemnification of the broker. The seller agrees to indemnify broker and to save, defend, and hold broker harmless on account of any and all loss, damage, cost, or expense, including reasonable attorney's fees incurred by the broker arising out of this agreement, a seller's misrepresentation thereof, or in the collection of any fees, commissions, the broker pursuant to the terms of the agreement. So that language has been added as additional protection for us. That's the only change on page 6. When we get to page 7, there are 2 new paragraphs that have been added. Those are paragraphs 35, dispute resolution, and paragraph 36. So under dispute resolution, for purposes of reducing the cost of each party of a dispute resolution, the parties agree that any dispute, controversy, or claim arising out of or relating to this agreement, so this is only relating to the listing agreement between the seller and McColly Real Estate, or any breach of this agreement or by either party shall be resolved by arbitration as opposed to going to court. And it'll be done under the rules of the American Arbitration Association and in front of an arbitrator. Tells you it would be done at the Illinois corporate office. And at the very bottom of that paragraph, all rights to a jury trial are hereby waived. On paragraph 36, again, language, all indemnities, limitations of liability, and waivers of claims by the parties hereto shall survive expiration or earlier termination of this agreement. This agreement, except as provided in paragraph 2, which is the starting and ending dates, technically all changes are going to have to be agreed to by all parties to the contract. And then it tells you other legal things, such as contracts that are signed by different parties in different places. So you have 3 sellers in different parts of the country. They all signed their agreement. Well, that's still only one agreement. It's binding upon their heirs, successors, assigns, things like that. And again, any cancellation, withdrawal, does not deny the parties any legal remedies that they feel they have under the agreement. So again, just more legalese, if you will, in those two paragraphs. And then on page 8, under the MLS submission information, you authorize McColly in your absolute discretion to submit the property as a coming soon and acknowledge that marketing the property as a coming soon is in your best interest. And therefore, you have to have the executed private listing network formed, which will be attached to this. And so your sellers should initial, if in fact that's what you're doing. And then it says, seller hereby acknowledges receipt of a signed copy of this agreement and all attachments. The attachments include the following, and then, so for example, the PLN form would be then attached because it's part of the agreement. And then the last paragraph simply talks about any further conditions that may be agreed to in the listing agreement. Then you have the signature page and the effective date of the contract. Again, they're going to have to do some reformatting because mine, on the next page, they have a phone and an email address. Well, we're going to want to get that back with all the other information rather than leave it standing on its own on a single page. But again, that's just a formatting issue. All right, so let's open it up to questions, clarifications, things like that. And you'll have to unmute yourself if you have a question.
Hey, Tim, it's Jeff.
Hey, Jeff.
Offline, I'd like to talk about, I think it's difficult to vision using one form for residential and commercial. I think the lease language is much different. You know, we're often opting out of the MLS. And I think if we use this agreement, we go into a commercial meeting looking like this residential company, you know, where we're talking about, you know, personal property and some other language, you know, on the fixture and personal property. And maybe that's a conversation. Is that a conversation with Ron?
Yep.
Okay, thanks.
I'll just throw my 2 cents in, which is pretty much I agree with you. And I've had a couple other commercial agents talk to me because you raised this concern at the meeting that, for example, that leasing paragraph does not cover the different issues you encounter in the commercial world.
Yeah.
And so they expressed that same thing. And so I would, my personal input, I would agree with you.
Yeah, I'll lead the conversation then with, I'll call it corporate. Okay, like sitting here, it just, this won't work, but we'll find something that can.
Yeah, I think we live in 2 different worlds. I think we got to keep them separate.
Yeah. Okay.
Any other questions we might have? Can't be that easy.
There's two questions.
All right.
One is, do we only use the new form after 8/17, or is this effective immediately?
The question, do we not use this form until after August 17th, or is it effective immediately? Lionel, you can better help me with the zip forms in Illinois.
Yeah, we can update that at any time. So as soon as we have it updated, we can have it scheduled for them to basically map it out and release it as soon as it's ready.
So again, once we get our final version here and try to get through and make sure we haven't done or not changed something that need to be changed to get our final formatting provision, then we submit it to zip forms. It probably takes them a week,
2 weeks.
2 weeks.
Yeah,
So would it be safe to say we'll make the shoot for July 1st?
we can get it if we have everything ready to go. We can submit it and have it ready hopefully by July 1st.
Or close to?
Or close to it, yeah.
So July 1st will probably be the target date, give or take a couple days. Again, how quickly zip form gets it done, maybe it's, but no, we're not waiting until August 17th. And Andy, maybe you can answer this, or Althea or Rich if you're on the phone. Has the MLS over there made any indication when they're going to be implementing these practice changes? Because the date I'm seeing is August 17th. That's the date that NAR agreed to, and well, they agreed to a July date, but then that got extended. But I saw a notice today from NIRA, our Indiana MLS, that said they're implementing the changes on July 1st. So I don't know if you've heard anything different in Illinois as to when those two.
I haven't, Tim. It's still the August as far as I know.
Okay. Andy, Althea, anything different?
Agree. I haven't heard anything from the board perspective either.
All right. But again, that's the practice changes we're going to get into next. And that doesn't have any bearing on this listing agreement, which will be in effect as soon as it gets on zip form.
Billy Zixelis asked why a 3.6 and 2.4 and not a 3.5 and 2.5.
Question. If you didn't hear that, why 3.6 and 3.0 as opposed to say a 3.5 and 2.5? Well, as I mentioned earlier, some agents provide additional services on their own for which they pay additional fees, and they want the right to potentially have a little more leeway in what they can collect on the listing side. And the other one is we're trying to give you the opportunity to actually make a little more money. Over the decades I've been doing this, commission rates have been going down. Don't want to date myself too many times here, but if I go back 40 years, commission rates were 7%, and we split 50-50. Well, we learned we couldn't do that anymore, but then rates started coming down to 30, 25 years ago, they would have been 6. Instead of 15 years ago, they're still 6. 10 years ago, they're 5. Today, we're seeing 4 to 5. Well, we're just trying to give you the opportunity because you won't get what you don't ask for. If the seller says 3, well, if you ultimately feel that you have to negotiate, well, you've got some room there. But at least you gave yourself a starting position. So, for example, you commonly take the 3.6, but Mr. and Mrs. Seller, because of our relationship, I'm not going to charge you that, and you change it to 3. Well, you're not going to get more than you asked for. And so that's why we don't have the 2.5. We're trying to encourage people that, we've been in kind of a fairy tale market, whether that's good or bad in the last few years. It's not always going to be that way. So, and at time of listing the property, I've got a lot of experienced agents here. You really don't know what level of service you're going to have to bring to the transaction. In my subdivision, we have a listing. It's not my listing, even though I live in the subdivision, but the agent listed the property over a year ago. When she listed the property, I looked at it and said, no way on earth that house is selling for that much money. So she has spent over a year working with this seller, get them to comprehend the realities of the marketplace. And about 10 days ago, they finally have an accepted purchase agreement. It's under contract. Now, a price that started off over $600,000 and ended up somewhere in the $470 range, that's a lot of work. And so, again, we want to give ourselves a fair opportunity to earn what we hope will be a reasonable listing commission. I hope that's a long-winded answer for probably a short answer question. But anyway, that's why.
She just said the 0.6 is odd instead of using 0.5, which is half.
The 0.6, confession, I have no idea. I was not part of any discussion about those two. So 3.6, 0.5, take the difference between 3.6 and 3.0, well, basically you give yourself a 20% increase. 2.5 and you went to 3.6, it's 44% increase in your compensation. So again, we're not saying you don't have the opportunity to negotiate it, but we just want to give you what we hope will be a reasonable starting point, and hopefully you'll be able to maintain that. Okay, how about this one? Well, what about certain other situations, such as a builder where we are doing something for a flat fee? Fine. So at the top of page 3, you put the line through those, say, see further conditions, and under further conditions, spell out what this special commission agreement would be. So we're not trying to take away anybody's latitude. We're just trying to give you hopefully a good position. Fair enough. All right, Lionel, any other questions?
No,
All right.
she was just asking if that was a typo, but that was intentional, right? The 3.6.
Yes, that was intentional. Well, if there aren't any other questions, or if you think of something later, send me an email, talk to your manager, Rich, Andy, Althea. Again, if you get any other questions, let me know. We can also take steps to address those.
Tim, I have a question for you.
Sure.
So correct me if I'm wrong, and this is what I've been hearing. So in order for you as a buyer's agent to go out and show a house, I have to have the buyer's agreement, agency agreement signed prior to showing a house.
Before touring a property, that's what we're getting into next.
Okay, yeah. Go ahead.
All right. So after the end of the listing agreement, you have a page that says NAR member practice changes effective August 17th, 2024, or earlier if the local board implements them earlier. Again, I was actually taken by surprise today. This is the first time I saw NYRA come up with this July 1st date. Not that it matters, but so anyway, as part of this whole settlement, and again, I won't get into the history unless somebody wants me to go there. But anyway, part of the settlement that they reached to bring all of these class action lawsuits to some finalization, and I will make a caveat here. There are some parties to some of the lawsuits that are opposed to this agreement. In essence, they're saying, hey, we never got our chance at a day in court. We still won. So there are some appeals going on. But I don't think that's going to affect these practice changes. I think that's more of a money situation, is why they want to go to court. So we're going to make the presumption, because we have good reason to believe that these are the practice changes that are being implemented. Now, this isn't the law. We have two bodies or regulatory agencies. We have the licensing agency, and those are the license laws and administrative regulations in your state. But because we are a member of the National Association of Realtors, we agreed to abide by NAR's practice policies. And therefore, as a NAR member, we have to abide by these changes. So basically what they are is, and it focuses primarily on a multiple listing service, because the multiple listing service has been the conduit through which we make our offers of compensation. So going forward, MLSs have to eliminate and prohibit mandatory offers of compensation through, again, a board-related multiple listing service. Also, the prohibition of making any offers of compensation through an MLS, any compensation fields on MLS input have to be eliminated. Eliminate and prohibit requiring or accepting an offer of compensation as part of a cooperation agreement. Agree not to facilitate offers of compensation on any non-MLS mechanism, for example, a third-party website. So a third party, an aggregator that pulls information out of the MLS, nope, they cannot be the tool through which we communicate any offers of compensation. That there has to be a written agreement. And again, it doesn't say an agency agreement. It's whatever agreement would be allowable under state law. I think most of us would say, yes, but we're going to be using an agency agreement. Having a written a written buyer agreement before the buyer tours any property. And those agreements have to specifically disclose how the rate or amount of compensation will be calculated. It's going to show the amount of compensation, and it has to be objective and ascertainable, not some open-ended figure, such as whatever a seller might offer. Nope, it's got to be a number, and a prohibition receiving any more that is in what is in the buyer agency agreement. The purpose of that is to eliminate what's called double dipping. And talking to agents in both Indiana and Illinois, a few of them have told me circumstances where that happened, where the buyer agency accepts the offer of compensation being offered through the MLS when they sell our listing, and they're also collecting a buyer agency fee from their buyer. Now, when we get into the buyer agency fee, it has language basically stating that if the buyer agency receives any compensation from the seller for a buyer agency fee, it will be deducted from any obligation that the buyer has regarding compensation. But there have been some agents that have, in essence, eliminated that language, and they're collecting on both. So the reason for that, to eliminate that potential practice. Also says you cannot represent any services as being free. That was used in the industry. Buyer services are free. Well, then the Code of Ethics said that if you're going to say free, you have to start referencing any other compensation you might be getting somewhere. But then this year, the Code of Ethics changed, and they said, no, unless you're not getting anything from anybody, you don't get to say free. Any offers of compensation from a seller must be in writing and presented before any actual payment of that compensation would occur. Any agreement must specify in writing that commission rates are not set by law and fully negotiable. And we've got that language in our listing agreements and also in our buyer agency agreements. And prohibit any search filters based upon offers of compensation. There were some MLSs that allowed the MLS participants to set up a parameter in which they put in a property search on behalf of a buyer client, but they could specify the minimum amount of BAC to be shown. So if they said, don't show any properties with a BAC less than, say, 2.5%. So I don't know about your MLS, whether that was allowable then. It was not allowable over here in Rapatoni, but in some areas that was a practice. Well, not anymore. So what are the clarifications? Working with means an MLS participant is providing brokerage services to a buyer. Now, this doesn't include an MLS participant who might be simply talking to a buyer, like at an open house, or providing access to a listing to an unrepresented buyer. So, for example, you're sitting in an open house. At that moment, you are the seller's agent. You are doing an open house as a benefit to your seller client. A buyer comes in unrepresented and they want to tour the home. Do you have to have a written agreement? No. As we'll see at the end, good practice would say you probably should have them sign a non-agency disclosure so they understand at that point you are not representing them as an agent. Not to say that you wouldn't like to in the future, because we know when we hold open houses, one of the purposes is to meet potential buyers and have the opportunity to start working with them. Well, if I were to actually start working with them, which would include showing other homes, would include sending them information about other listings, whatever. Once I start doing that, I'm going to have a written agreement. But if I'm only providing services to my seller at that point, no. Dual agents. A dual agent, you represent both the buyer and the seller. Well, since you are representing the buyer, you're going to have a written agreement with that buyer. On the next page, further clarification. Well, as we kind of just said, touring a home means if you enter a home with a buyer you are working with, then, or entering a home with the intention of doing a virtual tour for a buyer who is not physically present, well, you need to have that written agreement. When we refer to home, we are talking about 1 to 4 unit residential properties, not commercial. The written agreement doesn't have to be an agency agreement. It can be any relationship recognized by law. Hosting an open house, as we said, again, wouldn't trigger that written agreement, and that's for the good practice about the disclosure of non-agency. MLS participants may not receive compensation from any source that exceeds what was agreed to in the written agreement. So we talked about the double dipping. Any current buyer agreements that do not meet the new changes that go into effect on August 17th should be amended before August 17th to reflect any changes. So for example, if you have a buyer agreement and it makes reference to compensation from an MLS, well, that's not going to be allowed. So you'd have to take that out of your buyer agreement. Any offers of compensation made through an MLS on offers that were accepted before August 17th, that will not require a written agreement with the buyer unless Illinois requires it or would require it. I'm not aware of that they are. And if an offer to purchase has not been accepted by the date the MLS implements the rule changes, then any offers of compensation made prior to that will not be valid. So I cannot go back referencing, well, you said, well, what was said before August 17th regarding offers of compensation? Nope. Other anticipated questions. Okay, a buyer comes into my open house. They tour, they go through the property. And another good practice would be, do they have an agent? Because if they do have a buyer agency agreement already in place with another agent, well, then I probably want to know about that. Just as I would ask a seller when anticipating listing their property to make sure they don't have it listed with somebody else. So do you have an agency agreement? Let's say they say no, but now they want to make an offer. Okay, well, that can put you into a bit of a dilemma, because if they want you to sit down and write the offer, at this point, you do not have an agency agreement with the buyer. You do not have any compensation for buyer-related services at this point. And in all likelihood, when the buyer wants to make this offer that you fill out, they're going to be asking you questions about it. They're going to maybe want suggestions. And no, you can't do that. Not if they're not your client with whom you don't have an agency agreement. Now, I have one of the national trainers, I've listened to some of his stuff, and he suggests, for example, when talking with sellers and talking about potential buyers, that the seller be very hesitant in working with the buyer who is unrepresented. Because again, all the things that come along with buyer representation, so either having their own agent, or you acting as a dual agent, or having an attorney if they want to get their attorney to do this, but just operating with an unrepresented buyer can be risky to the seller, and create more risk that this thing won't get to the closing table. But again, those are just some of the issues that can come up. So what kind of questions might we have about these practice changes? So Andy, was that a good about touring the home?
Yeah, that's good. I just want to make sure we covered it.
Okay. Lyle, are we seeing any other questions?
No, nothing else.
Question, how will we know whether a seller will be offering potentially buyer agent compensation if we can't even talk about it? Well, the rule is it's okay to talk about it. Okay, question, will McColly write their own buyer rep forms? We're kind of waiting until the dust settles, to be honest with you. We're looking at the state forms and what changes. In Indiana, I know the state's gonna have to be changing their buyer agency form. And then I learned yesterday, right before I did my first meeting, one of the agents who's heavily involved with our board calls, oh, the state's got a new buyer agency agreement. I said, well, I know they were talking about it, but have they finalized it? Yeah, I think so. Well, then I checked with the state and they said, no, we are finalizing it, but we don't have it yet. And it'll go to zip forms and they're targeting July 1st. So we're kind of waiting to see what problems arise before we put out a form, which we learn in the not too distant future, that we just got to go back and try to change it, which would be very confusing. So we're going to kind of see how the dust settles on that. But where do they start to go on this? Okay. Well, how does the other agent know whether or not a seller is going to be offering potentially buyer agency fees? It is okay for you, the listing agent, to directly communicate with other agents the willingness of your seller to do so. So, for example, a showing gets scheduled on your property. You could contact that agent and say, just want to let you know, my seller has a willingness to potentially pay at least part of a buyer agency fee. If you have a number on the listing agreement that they said, yeah, I'll do that, well, you could communicate the number. Myself, I just would rather be able to tell the other participating broker that my seller has indicated a willingness to do so. I don't like to tie a number into it because if the number is higher, then the seller might be more reluctant. I didn't agree to that, whatever. So how might you know? Well, my suggestion is when working with the buyer, you just make the presumption that the seller will pay. Just I make a presumption, for example, that a seller will pay closing costs. So I'm sure you've had buyers who you work with and the buyer says, oh, my loan officer says I need fill in the blank amount of money in concessions. And I'm sure you've all probably seen that. So do you, when looking for properties to show, check to make sure that any listing you're going to show, the seller's indicated they'll pay financing concessions? Probably not. We just kind of presume they will. And we write an offer, it gets presented to the seller. It's either going to be acceptable or it's not going to be acceptable. Nothing really changes. And I think we just need to make that presumption. Now, what's the worst that's going to happen? Well, the worst that's going to happen is the same as with any offer. If we have terms and conditions that can't be agreed to, well, sorry, we'll have to move on to another property. I've had other agents say, well, what if the fact that my buyer is obligated to pay compensation and an offer that they are competing against doesn't have that same provision, well, then my buyer might lose out. All right. Position number one. This isn't something that is binding on McColly agents. Every member of NAR has the same obligation. So it's not like the buyer can go to another company and they're not going to have them sign a written agreement. You have to have a written agreement. And with the elimination of offers of compensation, that written agreement better have some buyer agency compensation. So unless that agent is working for free, the offers you're competing against probably will also have the same provision. I don't know if it'll be the exact same amount, but it doesn't really matter because, as with any case, it's just possible there is a better buyer that is willing to, bottom line, get that seller more money than your buyer could or would. And it happens all the time. So we just have to position that. Okay, other questions?
Already answer the question if McColly will write their own buyer rep forms.
Yeah, I answered, just to clarify, so about will we write our own buyer rep forms? We're just waiting to see where the dust settles on this and see what issues we have with the state forms that are available to us. And so it's possible that we will. And again, we are looking at practices from other states that have been doing this. And of course, through the Leading RE network, we get good feedback from some of our other members, and they let us see what they're doing. They let us see their forms. And if we think there's something that, is adaptable for us, that would be better than what the state gives us, that's what we'll do. Any others?
That's
All right, then. So then let's take a look at your next 4 pages, which are your 2 buyer representation agreements. The first one is the non-exclusive buyer representation agreement. So on line 8 and 9, the buyer hereby grants to brokerage the non-exclusive right to represent the buyer in the acquisition of property. So just as within your listing agreements, you have to have a designated agent, so that name goes in there. The other language hasn't changed. But then the clarification on line 21, buyer agrees to work with the designated agent and designated managing broker in the acquisition of property with the understanding that the buyer's relationship is non-exclusive. The buyer represents, the buyer has not entered into any exclusive representation contract that is currently in effect. And the buyer understands that the buyer may not enter into an exclusive buyer representation agreement with any other real estate brokerage. Question, just in general, has anybody regularly been using these? Andy, Althea, Rich, any of the associates? Has anybody really been using these to any great extent?
I have.
Oh, Rich?
Yeah,
So
I have.
What's been your experience? Do you use the non-exclusive or the exclusive?
No. I have not used them.
Oh, have not used it. Okay.
We have a couple agents that do, but not exclusively.
Not exclusive, meaning they don't use the exclusive one, or they
No,
don't
I
do
mean,
it.
Not all the time. We have a couple agents that do it, but they're getting them more signed off on when the contract's accepted or presented as compared to ahead of time.
So it kind of sounds like you're pretty much the same as us. We've always been relying on the offer of compensation coming from the listing broker.
Correct.
So then it tells you the term, of course, a beginning date and the ending date. Now, I've been getting questions on this one because unlike the listing contract, which we default to a year, now homes that are selling are not taking a year to sell. Would you agree that most homes, when reasonably priced, you're probably still getting them under contract in the first 30 days? Would that be kind of right, you think? All right, so let's presume that, no, I don't think it's going to take a year. Well, then why do I need a year contract? I gave you the one example is I don't know how long it's going to take to educate my seller as to the realities of the marketplace. And they've only got one home to sell. But with the buyer, I think it's going to depend upon your relationship with the buyer. Somebody calls you because they saw your name on the sign writer and they got your number and they call, hey, I just want to see this house. Okay, well, at this point, I'm representing the seller, and if I want me to provide brokerage services, I need to have a agreement signed with you. So they don't want to sign anything. And if I said, and it's only 90 days, and if it's exclusive, that means you can't buy a house from anybody else but me for the next 90 days. I don't think that's like a realistic scenario. So it could be, it's just for this house, so just for this day. Or it could be for a 3-day window. Or you're meeting this buyer and you say, okay, why don't we do this just so we give ourselves the opportunity to know each other? Let's do this for 2 weeks. I'm going to show you what I'm going to start doing as far as the services I provide. I'm going to start getting you information. We'll be able to get in on a few more houses, and we can evaluate at the end of the 2 weeks to see if we feel we're a good fit and we can continue. So I think it depends upon your relationship. I've had agents tell me, well, I've had these buyers that I've sold them half a dozen properties. Whenever they see something they might be interested in, they call me. And I got to have this agreement every time. Well, if you have this and you have a good rapport with them, and you say, under the new legal requirements, either the state law or my NAR duties, I have to have a written agreement with you. I appreciate the business we've done. I appreciate you guys have been loyal to me, and I love doing business with you. And I know that you always call me. So I'll just have you sign this agreement. I'll make it for a year. Okay? There. They probably wouldn't have any objection to that. I think you kind of analyze what your situation is with this particular buyer and how you're going to overcome that hurdle. Probably would be easier for the non-exclusive because, again, we're not stopping them from potentially buying a for sale by owner. We're not requiring them to compensate us, for example, for buying a for sale by owner or whatever. And if you got to page 2, on line 52, that's where we get into, for example, is there a retainer fee? The designated managing broker duties, the buyer duties, those are the same as they've always been. It's not very likely you're going to be getting a retainer fee on residential property. It tells you it is a non-refundable retainer fee, which says that I get a retainer fee from you in the amount of whatever. When we find a property, it'll be applied to the property as part of or in addition to the earnest money. But if we don't find a property, I get to keep it for services rendered. So it makes it non-refundable. So again, residential real estate, you're probably not getting a retainer. Then it spells out the compensation as to what it's going to be. Lines 84 through 86. The designated managing broker will make every effort to collect the compensation of the brokerage fee from the seller or the seller's brokerage. If the amount being offered by the sellers or seller's brokerage exceeds the brokerage fee that is identified in the written buyer agreement, designated agent shall disclose this to the buyer, and any amount offered by the seller or the seller's brokerage exceeding the brokerage fee may be retained by the brokerage. Not anymore. So that's going to have to change because that's not going to be an option. You're going to have to be limited to what you put in your written buyer agreement as to what your maximum compensation will be. It could be refunded to the buyer. Okay, we had to amend the contract, and for whatever reason, they were paying more. Okay, that can be credited back to the buyer. Or negotiated at the time of the purchase agreement, which means, I'm presuming, when you are sitting there ready to write the contract with the buyer, then you can negotiate whatever it will be. But again, under our new practice changes, sorry, you have to have that written agreement stipulating what the compensation will be before touring a home or providing brokerage services to the buyer. All right, all the other information remained the same on those. And then the second one I gave you is the exclusive buyer representation agreement. The buyer understands and agrees with that they are buying exclusively from you. So on line 20, buyer understands that this agreement means that if the buyer acquires any property, whether through the buyer's own efforts, the designated managed broker and their agents, another real estate agent besides the brokerage, or any third party, the buyer will be obligated to compensate the brokerage pursuant to paragraph 7 of this agreement. So you have the option of using an exclusive buyer representation agreement or non-exclusive. Again, what's your relationship with your buyer? And again, somebody you don't know from Adam, we've met them once. The likelihood of them entering into a long-term exclusive buyer representation agreement, I think might be a stretch. So again, what's your relationship and go from there. But that's what makes it exclusive. And again, the buyer is affirming they have not entered into any other exclusive buyer representation agreement that is currently in effect. So line 31, here's the term of the agreement. The other things remain the same. On page 2, again, the designated managing broker duties, the buyer's duties, except line 2 to work exclusively with the designated agent to identify, view, and acquire real estate during the term this agreement is in force. Again, the retainer fee, which we talked about, here's what the compensation will be, and the same issues of any amount over and above what the buyer agency calls for. So, any questions about the use of those two forms? And I'm sure you're going to be having more discussions when you do your own meetings and the practice, what you see happening in your market and so forth. So let's then talk about some of the issues that you might deal with when talking with sellers and buyers about concessions. So the next page talks about, should a seller consider paying concessions? Now, is it fair to say for many buyers, the problem buying a house is coming up with the necessary funds for the down payment and other transactional costs involved in purchasing a home? And that's probably especially true for first-time buyers. Coming up with $25,000, $35,000, $40,000, $50,000, that can be very difficult for somebody who, again, is looking at maybe buying their first home. Maybe they're both working and they've got good income, and even at today's rates, they can afford what a mortgage payment will be on a $300,000 house. And of course, generally speaking, do they want to buy a lesser home that doesn't have as many of the things that they would like? Or do they really at this time want to find a property that offers as many things as they can get for what they're willing to pay? And I would say most people want the second option. So let's talk about this first-time buyer that's got $25,000 cash to work with. And they're looking at a purchase price in the range of $300,000. In Indiana, that's about our median sale price. Now, I know your markets can vary, but it's probably not going to be too far one way or the other. So they've said, we're going 5% down to conventional because we've got good credit and our PMI will be less than what we would have to pay under the FHA mortgage insurance premium. And of course, the PMI can be dropped once we reach that 22% equity position. So that's why they want to go insured conventional. So on that $300,000 house, they need $15,000 for down payment. Closing costs. I know Illinois' closing costs are somewhat higher than they are in Indiana. Indiana, we're somewhere between 2 and 5%, depending. So I use 3%. And that probably won't be far off in Illinois either. So we'll just say they need 3% for their other closing costs. Well, that's $9,000. And they've agreed to pay you a buyer agency fee of 2.5%. That's $7,500. They need $31,500. They've only got $25,000. They're $6,500 short, and there's nowhere else they can turn to get it. They're not getting it from a parent in a gift letter. They just don't have it, can't come up with it. So guess what? They're not buying this house at this time. Well, what if the price of a property they looked at was only $235,000? Well, would you agree that there's a big difference in what you're getting for $300 and what you're getting for $235? But anyway, they still have the same 5% down payment, which in this case would be $11,750. They still have the same 3% closing costs. That's another $7,050. They're paying you 2.5%, $5,875. Total $24,675, which gets them to the closing, and out of the closing with $325 in their pocket. And they go out to dinner, celebrate, buy a tank of gas, and they're pretty much done. That's not even taking into account that the lender probably wants some reserves somewhere that you aren't spending every last penny just to buy a home. But again, it severely hurts the purchasing power of the buyer when they start taking money out of their pocket and they have to apply it to an out-of-pocket buyer agency fee. So let's look at one other. Again, we got $300,000 purchase price again, same down payment, same closing costs, same buyer agency fee of 2.5%. But in this case, we're asking the seller for 3% in concessions, which is a total of $9,000. So now the buyer only needs $22,500. They had a surplus of $2,500. The difference is the seller, in example number one at the top, would have gotten $300,000 minus their seller-related transaction costs. In this case, they're getting $291,000, then minus their seller-related transaction costs. So the question basically to the seller is, okay, does this work for you? You might have wanted to get the 300. We're at 291. Is that acceptable or isn't it acceptable? Just have we have any other offer that doesn't meet the total demands that the seller has asked for. But what this does is open up the size of the buyer pool to a lot more buyers who can make the monthly payment, but they can't afford a sizable down payment, especially if they have to take a bunch of other money out of their pocket to pay directly the buyer agency fee. So having the discussion with the seller and maybe even showing them an example. Again, Mr. or Mrs. Seller, it's up to you. But I'm just suggesting to you that we, again, remain flexible and try to attract as many potential buyers as possible, because the bottom line still hasn't changed. Generally speaking, the buyer that likes your home the most is the buyer that will pay you the most. And again, the more potential buyers we can open it up to, the more better chance we have of actually getting you a higher offer that will put more dollars in your pocket, sellers. Does that make sense? Again, I was just reading some stuff today about what they think will happen, and they're talking about, well, it'll drive some buyers out of the market. Well, if you drive buyers out of the market, inherently, what happens to demand? The demand goes down. And when demand goes down, what happens to prices? Well, prices will reflect lesser demand. For those of us that were in business in 2008 and 2009, we saw what happened when demand drastically dropped, and what happened to prices all around the country. One other note, if you're not aware of this, Fannie and Freddie and the VA have made a determination when it comes to seller concessions to the buyer. So financing concessions under conventional financing and under FHA financing, it is allowable for the seller to give 6%, up to 6% concessions, financing concessions to the buyer. Closing costs, prepaids, discount points, things like that. Well, the question, will that be impacted by a buyer agency fee? And they have said, oh, by the way, VA is 4%. But they have all come out and said, no, if the seller is paying a buyer agency fee, we will not deduct that amount from the 6% concessions they could have received on the financing end. So if the seller agrees to pay a 3% buyer agency fee, the seller can also agree to up to 6% in seller concessions, financing concessions on a conventional FHA loan. And then further clarification, I saw yesterday or today, the VA, which if you're familiar with the VA does not allow buyers to pay buyer agency fees. Well, they do now. So they said they've reevaluated And they're taking the position it is allowable for the buyer, the veteran buyer, to directly pay a buyer agency fee. And they will reevaluate at a further date if they think that needs to be changed. But in any case, if they're still getting it from the seller, doesn't matter either way. So I think having that discussion with both buyers and sellers, it may be showing them some of this stuff. The last thing that Fannie and Freddie want to have happen will be price drops. Given the number of mortgage loans that they own, many of them are high loan to value ratios. They really don't want values going down, which could cause mortgage loans to go underwater, as we experienced back in 2008. So we'll see how it plays out. But again, talking, and I thought I saw Taylor on earlier. Don't know if she's still here, but in Wisconsin, again, in talking with her and others, it is just common practice that Mr. and Mrs. Seller, you can expect that the offer from a buyer probably will have a buyer agency fee. I've got another friend in South Carolina, same thing. They've been doing it for years. And he says, yeah, that's pretty much the same thing. So I find it a little disconcerting because I've heard the AARP, for example. I saw this a couple of weeks ago where they put out a notification, great news for their elderly home sellers. You'll be saving thousands of dollars in commissions that you otherwise or used to have to pay. And I really find that either disingenuous or coming from a very uninformed position. But those are just the things that we have to overcome. So we need to work with our sellers to get them maybe to understand that there actually can be a benefit to them offering some concessions, because it does open up that buyer pool, and getting buyers to understand that we will try to negotiate a purchase agreement so that you're not taking money out of your pocket that you otherwise could be using as the down payment on a new home. And we also have to strengthen our presentation skills, getting parties to understand that real estate transactions have costs. And both parties to the real estate transaction have transactional costs. And that's a good term you should start incorporating in your discussions. So Mr. and Mrs. Seller, buyer agents cannot work for free. They cannot provide buyer agent services with no promise of compensation, just as we can't provide listing agency services without a promise of compensation. And how many of you have had buyers that you have literally worked with for months? I'm sure every hand or anybody still on this webcast would agree with that. You worked with them for months. They've made 4 other offers, which they didn't get because it was a multiple offer situation. I've shown them dozens and dozens of homes. And in a recent NAR survey, when they questioned buyers about the home buying experience and working with an agent, and they asked buyers to estimate how many hours their agent spent on the transaction. And the majority of responses indicated that they felt that the agent with whom they worked spent less than 20 hours on the transaction. When they talked to real estate agents and they started saying, if you add up all the time you're working with buyers, and about 80% of the agents said we spend on average more than 80 hours. Because if you stop and think about all the hours you spent on all of those transactions that never happened. I tell this story because I still want somebody to beat my record. Years and years ago, it was a referral situation, and I had people moving up from the Indianapolis area. He was taking a promotion in which he was going to become a regional manager for his company, and his region accompanied Northern Indiana and Southern Michigan. They were moving up from Indianapolis. So the way it worked, They would come up on Sunday night. His parents lived in Highland. They'd stay with them for 2 or 3 days. She and I would look at houses for 2 or 3 days while he went to work. And because it's relocation, we are seeing 8, 9, 10, 12 houses a day. And we're covering Lake Porter and sometimes into Jasper County. They made, half a dozen house hunting trips. I showed them almost 120 homes. One day she calls me and says, Tim, we really want to thank you for everything you've done. Boy, you were just so helpful. But Mike's decided not to take the transfer. There. So the idea is that I know it's hard for them to understand, and we got to sharpen our presentation skills. But again, you have to get compensated for all the time you spend when you potentially aren't getting compensated. So we need to hone our skills. Talk about the things that you're going to do with those buyers. Make yourself better aware of all the things we have on our website that are going to be helpful to those buyers. And anyway, the last page you have is the non-agency disclosure and consent. So again, if you find yourself in a position in talking with the buyer in which you are not acting as their agent, and again, you're doing, for example, an open house, good idea to have that signed. All right. So any other questions that we might have? All right. Well, so far nothing. Hopefully that wasn't too painful. But again, change is inevitable. It's going to make some getting used to. If you think of anything, talk to your manager, Kara. Oh, thanks, Tim. Great class. Appreciate it, Kara. Thank you. If you do think of something, talk to your manager, and get in touch with me. And if I can give further clarification, I will gladly do that. If you do have questions for me, again, I'd appreciate you going through your manager. We keep them in the loop. So we know what everybody's thinking. But again, I'm glad to address anything that might come up if I can. So again, if not, then appreciate your time and good luck.